All right. Good morning, ladies and gentlemen. May I have your attention, please? All quiet, please. Thank you. So we're going to do the lesson for government class. This goes out to my morning class for Friday, and then my afternoon class for the Monday after spring break, anticipating that we're not going to be back for that. So I'm going to go ahead and aim to complete this unit that we've been working on, civil rights and the courts. So you should have your notes out. We're going to be taking notes on that and take you all the way through it. And just a reminder at the end, just make sure that you click in and do the daily attendance questions so that we can mark that all down. Okay. So if you want to go to page 3 in the handout, I think in both classes we actually got to the same spot, which we've been doing all these different criminal justice rights and talking about some of the Supreme Court cases that added rights in the sense that the Supreme Court in the 1960s, being more activist, looked and said, for example, hey, if the police don't follow the rules, Constitution, we're going to exclude some evidence in trials. Mapp versus Ohio, 1961. Or if the police arrest somebody and they're in custody, they're going to have to tell those people who are arrested about certain rights: right to remain silent, right to have an attorney, right to have an attorney paid for by the state if they couldn't afford one. And that was the Miranda versus Arizona case, 1966. And of course, the other Supreme Court case we covered, Gideon versus Wainwright, said, yeah, if you are too poor to have an attorney in a criminal case, government's going to provide one for you. None of those things are actually in the Constitution, but that's how the Supreme Court read it in order to be more fair for criminal defendants. And to put, as they saw it, some meat behind those rights. Well, we're going to continue on. You can see right here, we've got the Sixth Amendment right to a speedy criminal trial. Not a lot to say there. You can see, I pretty much included that in the handout that I gave to you. 1 year is the Supreme Court definition of what a speedy trial right is. In other words, somebody is accused of having committed a crime. Well, we don't start the time from there. We start the 1 year from the time that they plead not guilty. And then the state has to have the trial taking place within that 1 year time period. Now, if the defendant wants to waive their right and extend a little bit more time and so forth, the court will allow that in most cases. But basically the idea is we're just not going to, the government is not supposed to kind of keep that trial going on and on and on and on and on and on and on. Okay. Slightly different. You can see in the handout, it talks about statute of limitations on charges. And I think we've talked about that previously in class. That's the idea of when a crime has been committed, allegedly, the state has a certain amount of time to bring the charge. Sometimes it's within a year. Sometimes there's no limitation. So for example, if somebody has potentially, I don't know, traffic infraction, run a red light, the state needs to bring that charge within 1 year. That's the statute of limitations there. If somebody's committed a murder, there's no statute of limitations on that. As long as the state's got enough good evidence and so forth, they can bring charges against somebody, assuming that that evidence is there, years and years after the crime occurred. So that's the Sixth Amendment right to a speedy trial. Let's continue. The next one on there is, yeah, here we go. Right against excessive bail for criminal defendants. Okay, that's in the Eighth Amendment. Eighth Amendment's got some interesting things going on there. We'll talk about the excessive bail requirement. If somebody is arrested for a crime and charged, do they plead not guilty? You know, where do they go? Well, if it's not a big deal, they court will say, you know, go home, come back on the day of the trial and so forth. Let's make sure you come back. Well, if it's a very serious matter, the court may say, well, we're going to make you pay some money in the form of a promise. We'll call that money bail. And you pay that, and then you're free. And your promise is to keep coming back to court on the days that you have to. And if you don't, you lose that bail. If you don't have enough money, you might go to a bail bondsman. Give the bail bondsman some money, and they'll put up the bail for you, whatever percentage of that amount it's going to be. Of course, they're going to make sure you show up too, because if you don't show up in court, they lose that money. They're going to come after you. Sometimes the charge is so serious, the judge will say, no bail. We're going to keep you here in custody until the trial is completed. And then, of course, if you're found guilty and you're facing a lot of prison time, yeah, we're going to keep you a little bit longer, a lot longer. So the right that you have is that the bail amount is not excessive. So that's a fairness issue as well. If you're charged with, reckless driving, I mean, they're not going to set bail at $500,000. Otherwise, you wouldn't get out of jail awaiting your trial. I mean, when's the trial going to take place? Sometime within a year. I mean, you're not looking at a full year's worth of jail for a reckless driving charge. So the court is going to evaluate all the circumstances, how serious the charge is, the likelihood of you being found guilty, how many ties you have to the community. If you live in the community, you've got a house, you've got a job, you've got family, you're not likely to flee. That will help bring the bail amount down. If it's a very serious charge, you're likely to flee, you've got very little connections to the area, that could bring the bail amount much higher. Okay, so they're going to look at all kinds of different factors to determine what's fair. Okay, that is your your Eighth Amendment right against excessive bail. Okay. Oh, by the way, O.J. Simpson, when he was charged with murder, what bail amount did they set for him? See, murder, very serious. And yeah, he was arrested trying to flee the vicinity in a white Ford Bronco, having been followed by lots of television, helicopters, and things like that. So he was actually in custody from the time of his arrest all the way to the end of his trial. And at the end of his trial, he was found not guilty, and then he went free. Okay. All right, let's go to the next one. Sixth Amendment, right to criminal jury trial. Okay. And this applies for felonies, misdemeanors, but not for civil infractions. We'll cover that. So you get a speeding ticket. That's a civil infraction. You can't ask for a jury trial. That's going to be, if you plead not guilty, that's going to be held in front of a judge. Okay. The worst you can get is a fine. But if you're facing a misdemeanor or felony charge, you go ahead and ask for that jury. You have a right to it. If you wanted to, you could have a court trial and just say, Judge, take a listen to all the evidence on both sides, and I'll let you decide. But it is very wise, if you're a criminal defendant, to stick to your right to a criminal jury trial. For example, if it is a jury trial, the jury in a criminal case needs to be unanimous for guilty or not guilty. And as long as they're not unanimous guilty, you're not guilty. Okay, you're not guilty until you're proven guilty. Of course, if you're found unanimous not guilty, boom, the state can't bring charges again. If they're a hung jury, and let's say you have 12 jurors on a felony case, and I don't know, 10 of them are like guilty, and 2 of them are like, not guilty. That's a hung jury. That case doesn't go away. It can be retried. They can start all over. So what situation? The story I tell has to do with a man named Claude Dallas, who was in the state of Idaho in Owyhee County, and he wanted to go hunting. Well, you can't just go hunting anytime you want. When you hunt in areas you're not supposed to, it's called poaching. It's illegal hunting. And he was caught. Claude Dallas was apprehended by a couple of fish and game officers from the state of Idaho. He ended up shooting them both and ended up killing them both. And ultimately, when he was captured, he was put on trial for like serious charges, murder charges, and so forth. But old Claude Dallas was a very effective criminal defendant, and he did a pretty good job as a criminal defendant in his trial. And he was not found guilty of murder. They found him guilty of like manslaughter, which is a much, much lower penalty. I mean, you did get prison, but I think he understood that if he's ever facing charges, always ask for the jury trial, because sometimes jurors can be very influenced by who the defendant is. In fact, Claude Dallas escaped from prison. He did, in Idaho. He escaped, went away, got caught, California, got brought back to Idaho, where he was charged with felony escape. There was a felony charge called escape. A jury was chosen because he pled not guilty to escape in the state of Idaho. A jury of people from Ada County was chosen, and they heard his defense. Basically, I mean, is there a defense to escape from prison? I mean, seriously, you're in prison. You're not supposed to escape. But apparently, there is one defense. You can escape because you're being treated really badly. But the only way you can like plead that defense is if you then turn yourself over to the nearest law enforcement officer and then get put in some other different prison or something like that. But nevertheless, Claude Dallas pled not guilty, had his trial, and a jury in Ada County came back with a unanimous verdict of not guilty to the escape charge. They put Claude Dallas back in prison for the rest of his manslaughter term, but no additional sentence for escape. So if you're ever charged with a crime, you're like Claude Dallas, ask for the jury trial, because you never know how a jury is going to look at your case. The jury in Ada County was pretty enthralled with old Claude Dallas. Eighth Amendment. Besides the excessive bail component for the Eighth Amendment, there's another part of it that says no cruel or unusual punishment. So the idea there is we don't want to get too innovative in the kind of penalties that courts could use for criminal justice. I mean, you could say, hey, wow, you know, we could keep all of our speeding cases to a minimum if we just executed all of the speeders on the highway. Yeah, I don't think we want to go there. Way back when, you know, when there wasn't a lot of law enforcement officials, somebody'd steal a horse and they might get away with it. So they really ramped up the penalties. And to really discourage people, they would, like, I don't know, stick them on a rack, torture them, you know, brutal punishments. But, you know, over time, 1800s into the 1900s, you know, we became more enlightened and had much better ideas as far as like criminal punishment. Incarceration, that's pretty much what we'll do for the most part, and some other creative things. But, you know, we're not going to like do like they did to William Wallace in the film Braveheart, where he was stretched out and then ripped open his guts and all of his bits and pieces and so forth were taken out. I mean, I suppose that was supposed to discourage Scottish nationalists from doing what they're doing, but yeah, our courts have said that's cruel and unusual punishment. So one of the areas that has really come up in the United States is death penalty cases. Is it cruel and unusual punishment to give the death penalty? And if so, how and to who and under what circumstances and so forth. So death penalty cases are very interesting. It's also called capital punishment. And it varies state by state. Some states have no death penalty for any crimes. Most states do have death penalty for a variety of crimes, very serious crimes, murder and so forth. The United States of America, federal government, has a death penalty for a series of crimes. And of course, if you're the defendant, you're wondering and challenging and so forth. You're like, can somebody get the death penalty? What do you guys think? In Europe, most other places in the world don't have the death penalty at all. The United States still does. Has the Supreme Court said that the death penalty is cruel or unusual punishment. Not wholesale, not lately, but around the edges, there have been various different decisions, important decisions on, is the death penalty cruel and unusual punishment? Well, again, it's up to 9 different justices. 5 feel one way, 4 feel another way, 5 is the majority. That's how it comes down. So what are some of the kinds of things that could come up? You want to write these down. Age of the defendant. Is it cruel or unusual punishment to execute an adult for a crime that was committed as an adult, if it's a serious enough crime, like a murder type thing? Could be. Well, what about a juvenile? What about somebody who is under 18? Well, the Supreme Court has looked at that, and they have said, if you're under 18 when you commit the crime, no death penalty. It's cruel and unusual punishment if you, to give the death penalty to somebody who was under the age of 18. The idea is like, oh, well, they're juvenile. They haven't really quite thought through things enough. We're going to put a bright line rule, 18. So could they get life in prison? Sure. So let's say a 16-year-old commits a really, really serious crime, kills a bunch of people, given life imprisonment. They'll be in the juvenile facility until they turn 18, and then they'll be in the adult prison population for the rest of their life. Okay, but they will not be executed. Got that? That's the way the Supreme Court has ruled in this country. Other question, what if their mental status, right? I mean, they may be 30 years old, but developmentally, they are like, I don't know, a 10-year-old or something like that. Okay. Supreme Court has said that it is unconstitutional, cruel and unusual punishment to give the death penalty to somebody who is sufficiently developmentally disabled. In other words, has a mental age of much, much younger than adulthood. So they can't get the death penalty. How the death penalty is given is also subject to Supreme Court cases, all right? So can somebody be executed by, like, burning them to death? No. What about hanging? What about, firing squad? Well, most states have gone with lethal injection, but there's a bunch of cases, looking into whether or not the lethal injection method is, fully comprehensive and doesn't cause all kinds of pain and anguish in the process and so forth. The electric chair is pretty much thrown out. That was shown, if you've ever seen the movie Green Mile, you know what I'm talking about. That was shown to be too cruel, I guess, according to the Supreme Court. So no state uses the electric chair. There was a guy in Utah who was executed, and he said, I just want to have the firing squad because that's for darn sure that that's going to work. So that was one of the options that they'd had. So states kind of go back and forth as far as how much, what methods can be used. But for the most part, lethal injection is the method that is being used. Okay. Let's see. Sixth Amendment. Oh, back to the Sixth Amendment. We got some more. And this one is the compulsory process to subpoena witnesses favorable to a criminal defendant. So think about this one. You have a right, if you're a criminal defendant, to have the government bring for your trial so that you can put on as witnesses all kinds of people who are going to potentially testify and help you be found not guilty. So think about this. So you subpoena a witness, and you're like, this person's going to be great on the stand because they're the one that actually did it. I mean, I was there, and now I'm being charged with it, and they're in charge. So they're going to be a great witness for me. So what do you expect, right? They have to show up. You have the right to subpoena them, and the subpoena is a court order. That person has to be at that trial on that day. So there they are, sitting in the chair, being asked a bunch of questions by your attorney. Questions like, so tell us the truth, right? My client didn't do anything, and you did everything, and you're the one that is really, really bad, correct? What do you expect that person's going to say? They have to be in the chair. They have to be in court. They have to be a witness. Are they going to answer the questions? Or is there something else in the Constitution that might help them out? Fifth Amendment. Yeah, they're going to take the fifth. They're not going to answer any questions that will put them in difficulty. They will remain silent. So just because you can get somebody to testify, to show up in court under the Sixth Amendment, right to subpoena, doesn't necessarily mean that they're going to be helpful to you. So you probably ought to kind of work that through and make sure that you've got that witness not only lined up, but have a pretty good idea of what he or she is going to say. Okay? That's pretty straightforward as far as subpoena and witnessing. Let's see. Yep. And then finally, let's talk about the ex post facto. We've covered that in past time. It's not an amendment. That's part of the original Constitution, Article 1, Section 9. And this is the idea that you're not going to be punished for anything that is a new law if the action that you did occurred before the new law went into effect. So we're not going to punish you after the fact. Ex post facto, you could get into trouble from here on out. All right, now that they've changed the law and made it illegal for you to do again what you did previously, but what you did previously, if it wasn't against the law, then you can't be punished for it. That's the whole idea behind ex post facto. Does that make sense? Okay, so let me pause right here for a moment. I put stop. So I hit stop. It says recording though.
Start video.
Okay, so we're wrapping up criminal justice, and a student, I think it was last year, shared a video with me, and I'm going to share it with you guys. And this is about it's a sketch. Some of you guys will recognize. Studio C did this about the worst attorney ever. So check this out.
Ladies and gentlemen of the jury, over the course of this trial, I will prove beyond all doubt that this man is innocent.
He's not on trial. She is.
Oh. Yeah, I'm not sure about her.
The whole truth and nothing but the truth.
Objection. Leading the witness. I'm really not sure how to prep for this case. Half of these are Harry Potter books. Your Honor, my client pleads the, is it the fourth or the fifth?
Are there any legal precedents for this case?
I'm glad you asked, Your Honor. Siri, Google legal precedents for goat robbery, the amendment that you plead when you're guilty. Objection! Leading the witness, probably. Also, define legal precedents. That's not good enough. I will not stand here and listen to you fill this hollow room of justice with your blatant lies. Now answer the question. I want the truth. Ooh, this is rough. The minimum is 5 years in Azkaban. Your Honor, could I request a short recess to see if my bar exam scores have been posted? I'm really hoping I pass this time. Can't fail 5 times in a row. You can't. This is my 6th time. Objection! Leading...
Miss Duncan, if you say leading the witness one more time, I will fine you.
Leading the person who witnessed something. Between you and me, the judge on this case is a total idiot. No, you don't need to type that. Stop it.
Mr. Jones, you were sitting at home, eating dinner, watching TV on the night of July 15th, weren't you?
Well, the night.
Objection? Leading the witness.
Sustained.
Oh, so that's what that means. Actually, never mind. I'm still confused.
We will now take a 10-minute recess.
Oh, good. I need this. I'm pretty sure the Miranda rights only apply to people named Miranda. Simple fact. You want to go? So, will you be paying me before or after you get sentenced? Because I would prefer before.
Hey, what's up?
Yeah, okay. Let's get back to this. Did you guys enjoy that? It's pretty good. Okay, so that was very interesting with the Supreme Court's rulings on criminal justice rights and so forth. And we've been looking at this issue throughout this entire unit, and that is the role of the Supreme Court and its involvement in civil rights and constitutional rights, and whether or not the court is restrained. Pretty much leaves it up to the executive branch, the legislative branch, the words that are actually written in the Constitution, or are they sometimes more judicially active, looking at the Constitution and saying, okay, we're the final arbiters of determining what those words mean, and in fairness, we are going to read those words to come up with a just decision. Keeping in mind, of course, that once the Supreme Court rules on interpreting the Constitution, if you don't like it, you guys know where this is going. What can you do about it? Not too much. You can hope the Supreme Court changes its mind. Rarely happens. The membership changes bit by bit. Amend the Constitution, which requires what? 2/3 of the House, 2/3 of the Senate. Got that? 3/4 of the states. And that's happened 27 times in our country's history, and only 17 times since the Bill of Rights was added to the Constitution. So the Supreme Court is very, very powerful. And we see that especially in the area that we're going to be going into now. In your notes on page 3, the last section there deals with privacy rights, the right to privacy, which is what? Well, we're going to be looking at some very important cases: Griswold versus Connecticut, Roe versus Wade, Casey versus Planned Parenthood, Lawrence versus Texas, among others. Okay, the right to the right to privacy. And we're going to start with a case known as the Griswold case, not the Griswolds necessarily from National Lampoon's American Vacation, but as it says in your notes, the government cannot interfere with the reproductive decisions of a married couple by preventing them from purchasing birth control. Oh. U.S. Supreme Court case, Griswold versus Connecticut, 1965. 1965, that should tip you off to something right there. 1965, who was the Chief Justice of the United States Supreme Court? Earl Warren. This is the Warren Court. Not just Warren, but it's most of the members of the Supreme Court that are more judicially active, that are willing to look at various different things in the Constitution and say, let's get, in their view, fairness. Let's get a just decision. So, what is the story behind the Griswold case, Griswold versus Connecticut? Well, you can see right here, 7-2 decision, 1965, finding a law that was passed in 1879 unconstitutional. All right, let's get some backdrop here. The law was passed in Connecticut, which at that time, still today perhaps, that time was predominantly Catholic, and the laws reflected the majority point of view of the people. And the law said that when it came to birth control, any kind of birth control devices, it was illegal. The idea was that any form of intimacy, even within a marriage, should potentially have the result of procreation, babies. And so therefore, no birth control means whatsoever were legal, okay? Whether it was married, unmarried, or any. And in fact, if you look closely at the laws of Connecticut back in those days, really the only people that could have legal intimate relations with one another were married people. But those people, married people, could not buy prophylactics, birth control, those types of things. So in the early 60s, an interesting thing came up. You had a couple, the Griswolds, they're married, and they can decide to have kids, sure. But they also decide that maybe they don't want to have kids. And the law of the state of Connecticut, passed in 1879, said they couldn't purchase any kind of birth control devices whatsoever. So, interesting question. Was there anything in the Constitution that said they had a right to have the ability to purchase birth control devices as a married couple? No, there's no specific right or amendment. Now, one could say, well, maybe they should go talk to the Connecticut legislature. I don't know, were there enough people in Connecticut in the 1960s that would say, yeah, we're not who we were in 1879. Or 1879, yeah, we're not who we were in 1879. Let's get the law changed to reflect more modern attitudes of our population so that, you know, maybe at least married couples could get that device. But no, the case went through the courts, and the argument made to the justices in the courts was that this is a constitutional right. And you're like, well, is it a constitutional right for a married couple to be able to have access to birth control? Well, you might think, what was that amendment that said, well, if we didn't put down our specific rights, we haven't gotten rid of those rights. Remember the right to freely travel? Oh yeah, the 9th Amendment. That's right, the 9th Amendment, which says we still have that right, even though we didn't specifically mention it, but we don't lose that right. All we have to do is prove that it existed when the 9th Amendment was there. So could they prove that back in, like, you know, the turn of the century between 1700s and 1800s, that the married couples had the right to have access to birth control devices? Could they bring up historical, factual evidence to say that that was a retained right, and therefore the 9th Amendment still has it? No. I mean, as that law indicates, there were plenty of other laws like that that basically said we don't want that sort of thing at all. So the 9th Amendment route is not going to work. So what is going to work? Where do you find a right to privacy that guarantees access for married couples, not anybody necessarily, but married couples, you know, because married couples, you know, they can have kids or they cannot have kids and da-da-da. And it's like, keep the government out of it. You know, it's none of the government's business whether or not they're going to be having kids or not having kids when they're having their intimate marital behavior. So where is it? Is it there? Now, strict construction, this court would say, if you want to amend the Constitution to add that, go for it. You know, get out there and get Congress and the states and so forth to go along with it. Or better yet, talk to the folks in Connecticut and get that law changed. But they had success when they went to the Supreme Court, because the Supreme Court, well, they ruled in their favor, as you can see right there. They ruled in their favor. They said that the state of Connecticut could not prevent, now listen carefully, married couples from having access to birth control. Now, if the state of Connecticut still wanted to deny that in 1965 to unmarried couple, sure, they could say that, because unmarried couples You know, the Supreme Court wasn't going to go there at that point. Unmarried couples shouldn't be necessarily having those intimate relations, but, you know, married couples could, and they could decide whether they were going to try and have kids or not have kids. So how do you get there? What's the logic? What is the Supreme Court rationale? This is interesting, okay? The Supreme Court rationale is that the right of privacy is in the Constitution in bits and pieces, and it appears in different ways, just depending on where you look for it. Okay, so let's look at that. Supreme Court said, the foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from the guarantees that help give them life and substance. Various guarantees create zones of privacy. That was by one of the justices of the Supreme Court. I believe he was the one who wrote this. Okay, where do you have it? Do you have it in the Ninth Amendment? Nope, not there. But where do you have it? Where in the Constitution is there something that basically says government, but out of these people's lives, they want to get together and kind of a, oh, wait, I think we got it. First Amendment, do you have a right to associate with who you want to and not associate with who you don't want to? That's part of the First Amendment. Does it have anything to do with how you associate with that person? Oh, maybe. And what's the one where the Constitution says, look, government, just stay out of my house unless you've got some kind of piece of paper that says you got business looking for evidence of criminal conduct in my house. You just better walk away. What amendment was that? Do you remember? Which amendment? Fourth Amendment, right? Search and seizure. Now, so those two amendments, the Supreme Court said, were, what was that? Penumbras and emanations. Oh, do you guys use penumbras and emanations as words in your typical vocabulary? And an emanation is light. A penumbra is like a shadow. And you could say, you know, the shadow proves the sunshine. If you see a shadow, you know that there must be some source. Huh? So what does that have to do with like law and constitutional rights? Well, the court is almost using like here, right? Here we go. There's the penumbra and there, oh, I'm sorry. Penumbra is like a half shadow. An umbra apparently is a full shadow. And there's your light source. There's the emanation. So basically, they're using kind of almost like a physics analogy to say, well, even if you don't see that right specifically in the Constitution, the right of privacy exists because it's there and it's in partly the First Amendment and it's also in the Fourth Amendment. First Amendment, right of association, you can hang out with who you want to. Fourth Amendment, the right against unreasonable search and seizure. Okay, so it's basically the Supreme Court is like, okay, we're going to say from here on out, we're going to call it the right of privacy. But it's there in the Constitution as we see it, proved by emanations, penumbras. Yeah, that's what we say. Now, there were some people when that decision was reached that were pretty upset in the sense that they're like, whoa, we're getting pretty fantastical in our judicial analysis here. You could pretty much say almost anything was an emanation or penumbra or whatever. If you say it's in the Constitution, then I guess you say it's in the Constitution, in fairness. But was there a big hue and cry from the population when all of a sudden in the state of Connecticut, married people could have access to birth control? Well, this was the 60s. I mean, this was like not considered a big deal. Important constitutional rights, important Supreme Court decisions can be reached and have big effects thereon after. In the case of very sympathetic circumstances, most people sympathized with the Griswolds. I mean, not these people, but the actual Griswolds, because they wanted to decide whether they were going to have kids or not. And they didn't want the government to get in their way. So rather than get the state of Connecticut to get it changed, and who knows if that would have happened and so forth, it might have taken some time. But they did get a decision by the Supreme Court. And the Supreme Court said the right of privacy exists. How big was it? very narrow. It applied to married couples having access to birth control. Did it apply to non-married couples? Not at that time. Did it apply to anything else having to do with sex or anything like that and so forth? Not at that point. But you understand how the Supreme Court works. When they make a ruling, other people look at that ruling and go, well, maybe this applies to such and such. Remember the whole series of cases we did with the right of marriage and equal protection. You got to make one decision here, and then it's followed by another, and then another. And how far along that slope do you go? How comfortable is the Supreme Court in saying, hey, these people have a constitutional right to get married. Oh, and these people have a constitutional right to get married. Oh, and et cetera, et cetera. You guys remember the discussion there. So is that where it ended? Is that where it ended? Well, you can see the Griswold versus Connecticut case, 1965. Actually, there were some people, I want to say, in their late 60s that they were not married, and they said, hey, that right of privacy also applies to us. We should be able to get birth control. The Supreme Court at that time said, nope, 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 nope. They didn't extend it that far at that point. But once that decision is made, it could be the basis of another important decision, and that's exactly what happened. The next case we're going to go into, very, very important right of privacy case, one of the most important cases done by the United States Supreme Court, and one that is still very much with us today and very much a hot topic for court analysis and politics altogether, including our presidential race right now. And that is the case Roe versus Wade, 1973, the right of privacy as it applies to pregnancy and terminating pregnancies, i.e. abortion. Okay, let's start off with the facts. The fact of the matter is that in 1973, in the country, there were quite a few states that did not allow for legal abortion. Some states did, some states allowed them under certain circumstances, and so forth. The trend was for more abortion rights to be allowed in more and more states. But as you can see here, like for example, the red shows all the various different states where it was illegal. It was legal in many other states, the green ones, in case the mother's health was endangered or had been subject to rape or incest and so forth. But nevertheless, this case arose out of a law in Texas. This woman here, known as Jane Roe in the case, although she has come out publicly since then, her name is Norma McCorvey, Norma McCorvey. And it's very interesting because at the time, I think she was going through the divorce, she was pregnant, and the law of the state of Texas says she couldn't get an abortion. That would have been illegal for her to do that. And she wanted to have the right to have an abortion. And, you know, well, you could try and get the Texas legislature and governor to go along with the change there, but her attorneys had a different tactic, and it ultimately worked. And that they went through the courts all the way up to the Supreme Court, and they had to go pretty quickly, and basically made the argument that, okay, the right of privacy that the Supreme Court talked about in Griswold versus Connecticut, that whole idea of that intimate behavior taking place and whether or not a pregnancy could occur because, you know, of access to birth control and so forth. Well, let's assume that pregnancy did take place. And now the pregnancy is located right there within inside the female. And, well, that's privacy. That's privacy. And the argument is the government shouldn't have anything to do with what happens with that pregnancy from that point onward. Because if you have, like many of those states, the government saying, no, you can't have an abortion. You've got to go ahead and finish that to term. Then that's going to have an impact on that female's life. She's going to go from early stages of pregnancy to later stages of pregnancy, and then ultimately, I guess this is how it works out, delivery. That's where it goes, and that's what the law was in many states. And you know, people who provided abortions could potentially go to jail, for example. Well, the Supreme Court, in that decision, Roe versus Wade, said that a female does have the right to have an abortion. and that is covered by the right of privacy, which the Supreme Court had announced previously. That was a big decision. That was in 1973. Did everyone like it? No. Did some people like it? Yes. Did some people want to get it changed? Sure. How do you get a Supreme Court decision changed? Can you just go up to the members and go, oh, we're not going to, oh, you don't vote for members of the Supreme Court. They're on there for life. Okay, well, what about getting a constitutional amendment? What's that going to take? 2/3 of the House, the Senate, the states, 3/4 of the states. That wasn't going to happen because mostly on the abortion issue, generally the two camps on either side of that issue, so-called pro-life and pro-choice, they tended to be sort of evenly split. In other words, you don't have like a 67% one way or the other generally, okay? You've got pro-choice, which like the Roe versus Wade decision, because they like females to have the choice of whether or not to finish a pregnancy with delivery or to terminate the pregnancy and have an abortion, okay? The pro-life focuses more on the unborn life inside of the female. So they're in favor of that life and say once that life has been conceived, that should be protected regardless of decisions of the pregnant female, whether or not to terminate that. So they call themselves pro-life. Of course, as you can see from the image here, and if you know of anyone who's been participants in any of the conversations between pro-life and pro-choice, sometimes one side will refer to the other as not necessarily by that. So for example, pro-lifers could call pro-choicers pro-abortion or pro-death, and pro-choicers could call pro-lifers like anti-choice and all kinds of different things. So sometimes it can get pretty intense. And I tell you what, it has been very, very intense over the years as the Supreme Court has taken up new abortion cases as with changed membership bit by bit by bit. And as presidential races have come up and as various different races in the states and in Congress have come up, this issue is still with us very, very, very much. But Roe versus Wade has not been reversed. Roe versus Wade is still the law of the country. It has been confirmed. So for example, let me go to this one. I'm jumping ahead here. It was confirmed, you can see it in the case Casey versus Planned Parenthood. That was a case that came out of the state of Pennsylvania. And the decision was written by Justice Sandra Day O'Connor, who was the first female appointed to the United States Supreme Court by Republican President Ronald Reagan. Now, Ronald Reagan ran for president as a pro-life candidate. And his supporters and he, I think, anticipated that when he had an opportunity to fill a vacancy on the Supreme Court, that he would endeavor to put somebody on there who would not support Roe versus Wade. And when he appointed Sandra Day O'Connor, who was, had a career in law and politics in the state of Arizona, some of his supporters said, are you sure about her? I don't know where she is on the abortion issue, da, 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 da. And he's like, well, I think she'll be fine and so forth. Well, when in the year, it was in 1992, when the Supreme Court was looking at various different abortion regulations coming out of the state of Pennsylvania, she wrote the decision. I believe that was a 5-4 decision in which she and the majority of the court reaffirmed Roe versus Wade. And part of her argument was, may have ruled differently if I'd been on the court back in the time of Roe versus Wade, but now it is precedent, stare decisis. The people have come to depend on the right of females to have an abortion. And so that's where she was. So the answer to the question, was she pro-life? Turns out she was pro-choice. Okay, so you never know. You think as a president, you've got somebody on the court that's going to rule a certain way, but members of the court typically are on there a lot longer than the person who appointed them. The president can serve like 8 years. Some of the members of the court have been there for decades. Can't touch them, right? They're going to go through and they're going to decide based on what they feel should be the law. Okay, now it's very interesting because as far as the actual pregnancy and so forth, different people have different views and so forth. I mean, and where does this actually impact, and what are your views? What are the views of the court? What are the views of politics relative to the different stages of a pregnancy? Now, keep in mind, I want you to understand this. The Supreme Court has ruled in Roe versus Wade and in subsequent cases that the female has the right to have an abortion, and that the government cannot provide all kinds of barriers to that right. And when does that right apply? Well, it applies at beginning at the time of pregnancy and throughout the pregnancy. So as long as the female and her doctor are in agreement, an abortion can be utilized at any point in time in the pregnancy. The right does not go away regardless of the maturation process within the womb. So this is always a very interesting thing. Just as a reminder to you, I'm pretty sure that there's, I don't know, test tube baby or something and so forth. But, you know, if you have questions about like how babies, where the babies come from and so forth, just make sure you ask Mr. Holliday, the health teacher, because he'll be happy to pass that along. But generally, as you can see from the slides up here, let's see, we have female here on the upper slide, far left. There she is. You can hardly even tell she's pregnant, but oh, look, she's starting to show a baby bump. And then as you go right up to there, my goodness, 9 months. That's usually what it is. Although sometimes people are born sooner. I typically will ask you guys, raise your hand if you know somebody that was born before 9 months. And usually we get some hands. Probably one of the key things that sometimes people will have as a discussion there is the point of viability. And that seems to be a very important point in some people's minds, as in at some point in a pregnancy, the fetus may be viable and can be sustained, live outside of the womb of the mother, right? Those would be like, for example, premature births. After that point, they could survive outside of their mother. But of course, here is the deal. In a pregnancy, Roe versus Wade, the Supreme Court says, the female has the right throughout the entire pregnancy. Okay, so that's what she looks like. Here at the bottom right there, you've got the embryo at 8 weeks, and it goes all the way up there. So you can see there's quite a bit of growth going on there. No big surprise. I mean, lots of room to move around and so forth. When you're little, you got little fingers finally starting to come in and so forth, but it's starting to get a little cramped by the time you get to 40 weeks. So that's when you pretty much have to be like, move along, move along. I do have one little video I think I could play for you here, just to give you a little bit of a sense. This is video of ultrasound at the various different stages. So if you look at the various different stages, you can see kind of where things are in the pregnancy, and because that's going to be an interesting and relevant point as far as where people come down on the abortion issue, supporting Roe versus Wade completely, to an extent, not at all, and how that plays out. So let me play this video for you of the ultrasound of pregnancy.
Only 2 cells are needed to create a baby. 2 cells and a miracle. In just 9 months, this pair of cells blossoms into billions of cells. Gently nestled and protected in a mother's womb, a tiny human thrives. Together, mother and baby share this journey of life, this magnificent adventure called pregnancy.
Get a heartbeat. first trimester. So I'm stretching out. Well, you're gonna have a thumb. Where's that thumb gonna go? Right in the mouth. I'm gonna give him a pencil and start taking notes in Mr. Hansen's class. Oh, there goes the thumb. Oh, I didn't see the middle finger, did you? Oh, that's a good joke. That was a burp. It's getting crowded here. Yeah. Time to go. Oh, Mom, got an appointment. We getting there? We there yet? We there yet? And up. There we go. Babies. Give me food.
I hope you enjoyed this video. Please click the link below to sign up for Pregnancy Chat, where it's our mission to nurture you through your pregnancy and childbirth.
Okay, thank you. All right. Let's get back to, so that's just kind of a reminder of like where the pregnancy is at. And it does affect various different views that people have on the issue of abortion and the right of privacy so that a female can have an abortion. Needless to say, there's been a lot of, oh yeah, there we go. Almost there. Oh, there we go. That's pretty small. I don't know how many of you guys were that small when you came out. Usually this is the point where I ask, you know, like, were you on time? You can't be too late. That doesn't happen. But some of you guys come early. Yeah. So anyway. And then of course, one of the things that's been going on ever since 1973 with Roe versus Wade, and it has happened even up to this day. And in fact, this year could be potentially very consequential in the Supreme Court on the issue of abortion. And of course, for the folks that didn't like the decision in Roe versus Wade, they're getting their views across to Congress and to the various different state legislatures and governors of the different states around there to do things having to do with abortion, and creating various different laws. And then, of course, if the laws are deemed to be too much of a restriction on a female's right to have an abortion, then the courts, and Supreme Court in particular, would step in and go, nope, 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 can't do that, can't do that. So there's been all kinds of different ones. Like, for example, here, the 5-4 decision, majority decision, very close. That was Sandra Day O'Connor who wrote the decision in the majority. Had to do with a number of other things, including waiting period. Let's talk about that. A waiting period. So is it too much of a restriction on a female's right to have an abortion if, when she goes into an abortion clinic, the government, the law of the state says you have to wait. You got to come back. Is it too much of a restriction? Well, some of you guys are probably asking, well, how long is the waiting period? Well, what if the law was said that you, when you come in to have an abortion, you have to wait 4 weeks before you can have that abortion? Would that be too much of a restriction on the female's right to have an abortion? I think you're probably going, well, yeah, I mean, that could be, because in 4 weeks, I mean, you saw the video, a lot can happen in 4 weeks, a lot of growth inside of the womb and so forth. And necessarily, when you're talking about abortions that take place beyond the first trimester and into the second or even into the third trimester, those are much more complicated surgical procedures. And so courts said that, 4 weeks is going to be way too long. What about 1 day? Is that too much? For somebody to go in, a female go into an abortion clinic and then be told that the law of the state says you have to come back the next day. Is that too much of a delay? Is that too much of a burden on the female's right to have an abortion? The Supreme Court said, well, 1 day, that's not too much, okay? So make sure you have that in your notes, because we got all these different follow-up decisions on the right to have an abortion. So 1 day, not too much, but when you start getting beyond that, that's where the Supreme Court comes in and goes, nope, 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 that's too much of an imposition. What other kinds of things did some states do with respect to abortion laws? Let's see, how about this one? The age of the person having the abortion. And this is why I always refer to it as the right of a female to have an abortion, not a right of a woman to have an abortion, because a woman presumes 18 years of age, an adult age. Well, females can become pregnant before that. Well, if a female is going to have, some kind of a surgical procedure, most laws in the country require some kind of parental consent before a juvenile female or juvenile male can have some surgical procedure. I mean, like whether it's like, I don't know, getting a tattoo or, a nose ring or, any kind of thing like that. So some states said, okay, females, if they're under the age of 18, have to get parental consent. Is that a limitation? Sure, it's a limitation. Is it too much of a limitation as far as Roe versus Wade? I don't know. What's the court going to say? Is that too much? Can a parent veto? Could a parent say, no, I'm not going to consent. We want you to, have the baby. We'll figure it out. Can the parents veto that decision? Well, a veto sounds like a limitation. And so the Supreme Court said, yeah, no, parental consent is not required. Well, wait. What if they had like an alternative? I think it was Pennsylvania that ultimately had kind of like a two-tier thing. Required parental consent or a judge. Like a judge, yeah. So if the female under the age of 18 wants to have an abortion, she can get signed off by a parent, or if they won't go along with it, go to a judge. What's the judge going to say? The judge cannot say no. But it's just one more adult that is going to be in the conversation before the decision to have the abortion is carried out. Okay, so do females have the right to have an abortion? Yes. Can a state put like a little bit of a barrier as far as like making them talk to an adult, maybe their parent or a judge? Yes, if they want to, if the state wants to. Okay. What about pamphlets? Some of the states were like, hey, we want to have requirements of pamphlets in an abortion clinic. Well, is that too much of a imposition? Pamphlets describing, I don't know, options of adoption, for example. Have the complete the pregnancy, do the delivery, and here's an adoption option, and other kinds of things in pamphlets. Is it too much of a restriction? Well, it depends. How many pamphlets do you have to look before you can have an abortion? I mean, do you have to go through a massive, stack of papers before you can sign off and have the abortion? That might be seen as too much of an imposition. A few pamphlets, perhaps not. Okay. What about the requirement because some states were like, well, before you can have an abortion, you need to check off that you've actually considered, the fetal development, requirement of an ultrasound before you have that. You get into all kinds of various different things. And again, it ultimately boils down, is that too much of an imposition on a female? Because that's the court standard. And if it's too much of an imposition and the female cannot carry out her decision to have an abortion, then that's thrown out. Okay. How about veto of the male? Because in most cases, males are partly responsible for pregnancies occurring. Well, what if the male's like, well, you know, I'm not really interested in abortion taking place? Can they veto it? Now, keep in mind, if a pregnancy results in the delivery of a child, that male is called a father, and he is financially obligated until the child reaches the age of 18. Unless, of course, there's an adoption, in which case then all of his rights and responsibilities are removed. But what about during the pregnancy? Can the father veto the decision? Can the male, who's responsible for the pregnancy taking place, can they veto the decision? Is that too much of an imposition on the right to have for a female to have an abortion? That's what the Supreme Court said. So, no laws by males. What if they're the husband? Can a husband veto a decision by a wife to have an abortion? Nope, can't do that. Okay, so those are deemed to be too much of an imposition on the female's right to have an abortion. Okay, gone through all kinds of various different ones. I think one of the ones that's being considered right now, and this is very, very interesting. This is the June Medical Services case coming out of Louisiana, where Louisiana and some other states have a law that they want to be enforced. And of course, now it's going through the courts and so forth. I think there was one in Texas that got thrown out, but there were two different justices on the court when the Texas case was ruled. The current case, June Medical Services versus Louisiana, now you've got Kavanaugh, Gorsuch, Alito, Thomas. See those four in your notes. Strict constructionist. Oh, and Justice Roberts, is that 5? Well, the Supreme Court listened to oral arguments on this case out of Louisiana. What was it? Well, the law of Louisiana says that if an abortion clinic wants to operate in the state of Louisiana, it has to have like admitting privileges with a nearby hospital. So if an emergency occurs during the process of the abortion, that female will be able to go very quickly to a nearby clinic. Okay, so the idea, as stated by the proponents of those laws, is that those females will have proper medical care and so forth, and bad things can't happen. Of course, the people who are against the law say, oh, that's, you know, that never really happens, hardly ever happens. And this is just an attempt by the state of Louisiana to shut down abortion clinics, because I think I read somewhere that there were like 3 or so in the state, and none of them were close enough to hospitals to have that admitting privileges. So if the Supreme Court said that was legit as a requirement, then under the current situation, then Louisiana wouldn't have any abortion clinics. So we'll see. How's that going to turn out? Keep an eye on the news. Folks are watching, right? I mean, this is a big issue in presidential politics. There are people who vote for president one way or another based on those presidential candidates' views on the issue of abortion and what kind of person they would choose to be on the Supreme Court should a vacancy arise. Will there be any vacancies arising over the next 4 years or so? I think so. Look at the ages of the justices. We have that in the early part of our notes. One very controversial case came up, and let's talk about this one. Write this down. This was a case that came out of the state of Nebraska, 2000. It's called the Stenberg versus Carhartt case. And I don't think I put that in your handout. I should have. Stenberg, can you read it there, or is that too bright? Stenberg versus Carhartt. Carhart. Came out of 2000. And that was a law in the state of Nebraska that had a limit on the type of surgical procedures that were available in late-term abortions. Now, there's not that many late-term abortions. Most abortions that take place in the first trimester. It's a much less complicated surgical procedure, certainly by comparison to late-term abortion procedures. And the state of Nebraska didn't like a particular form of late-term abortion procedure and sought to ban it. say, no, we can't allow for this one. Supreme Court looked at that and was like, well, is this a limitation on the right of a female to have an abortion, given that there's not a lot of variety of choices that you can have for abortion procedures when you get to the very, very later stages of an abortion, of a pregnancy. I don't have a lot of graphical things here. Yeah. But let's see if you can try and picture this, because the critics of these late-term abortions, they would call it like a partial birth abortion. And of course, proponents of the late-term abortion said, well, that's not realistic, and that's being, what are you talking about, a partial birth? Well, let's see if you can picture this in your minds and so forth. The procedure that they were talking about involved the method to try and make it as safe for the female as possible, given that the fetus was, 8 to 9 months along, pretty close to delivery. And you've got inside the fetus with a very large head compared to the rest of the body. And of course, an abortion procedure would want to have no harm to the female, because there's all kinds of potential things if you're talking about, a surgical procedure on her. Whereas, of course, the point of the abortion procedure is to terminate that which is inside and remove that which is inside so that it no longer remains. Well, the reason why the folks who came up with the Nebraska law call it partial birth is because the idea is to have the crown of the head start to make its way out, I suppose, in a natural-ish type way, so that it is partially out. And therefore, the largest part of that fetus, then the skull is collapsed. And then all is removed. This is the point where some students in the past were like, oh my gosh, please, Mr. Hansen, stop. But if you want to understand exactly what they're talking about, that's what they're talking about, a surgical procedure, whereas the head is, in a sense, on the way out, rather than have the surgery take place completely inside the womb, in which case then you have a lot of material to remove. This particular abortion procedure would have then the skull collapsed and then everything else taken out, and a lot less potential harm and leftover and so forth inside the female. Okay, you got that? And the Supreme Court said, no. Supreme Court said, no, a state cannot remove from the choice of the doctor and the female who's having an abortion any type of particular surgical procedure that may be available, because that surgical procedure might be the best thing, the best option available. Okay, now, of course, you are talking about late-term abortions, and that's what the Supreme Court said. So, female wants to have an abortion at any point in time during the pregnancy, that's covered. And that was the Stenberg versus Carhartt case. So some of you guys are wondering, well, what happens if a female is late term and on the way to an abortion clinic, and before she gets into the abortion clinic, in the parking lot, she delivers? Her intention going into the parking lot and then into the abortion clinic was to have an abortion. Could she have a legal abortion? Yes, no crime there. Well, what if she delivers in the parking lot? Can she go, well, I didn't mean to have that. Can she terminate life of baby in the parking lot? Nope, that'd be murder, okay? So the law is pretty much, as soon as what is inside fetus comes outside baby, it is protected by the Constitution, right to life, liberty, property, and et cetera, et cetera, et cetera. Okay, so due process rights, they can't just terminate you there. So it's a very interesting, distinction there. Here's one, because what if somebody comes along and, you know, punches a pregnant female, right in the tummy? Could they be charged with a crime? Well, what if she was on her way to carry out an abortion? Well, he's in trouble for hitting her. What if he causes additional harm to the fetus? Well, if her intention wasn't to have an abortion, then you could get in trouble for that too. But the idea is that the decision is entirely left up to the female. That's the basics for Roe versus Wade. Okay, you got it? Is it always going to be that way? I don't know. Keep an eye on the courts. End of June, early July, the June Medical Services case coming out of Louisiana. The Supreme Court has heard oral arguments. They did in early March, and they're in the process of figuring out what they're going to do. And it's going to be interesting as we go along. Is this an issue that is still very much part of the presidential debate? Mm-hmm. Yep. And Donald Trump, let's see, which camp will we put him in? Yeah, he is definitely for overturning Roe versus Wade. Who is against overturning Roe versus Wade? Supporters of Bernie Sanders, supporters of Joe Biden. Okay, so that's a dimension in it. I mean, it goes all the way back until like the first presidential elections after Roe versus Wade. This has been a very hot political issue. And because it's the Supreme Court, it's not one that can easily just sort of be like, you know, we'll just pass a law. There's a bunch of states that have passed laws saying if Roe versus Wade is overturned, then this goes into effect. Some law, you know, outline abortion, maybe under certain circumstances, but allow it in other circumstances. And I dare say you would probably have a variety of laws from a variety of states. You wouldn't have just one standard throughout the country, probably, depending on, you know, how the Supreme Court defined it. But right now, there's one standard and it applies everywhere, okay? This is something that I've done with students in the past, and I've had them do, and I'll be interested to see what you guys think. Maybe we'll figure out a way to take a measure of this as kind of a wrap up on this discussion of abortion. And that is that, you know, we've defined kind of, there's a pro-life position and there's a pro-choice position, but perhaps on closer analysis, the pro-choice camp actually is sort of two parts, and the pro-life camp is kind of two parts as well. And I've come up with my own kind of terminology here. I call the logical pro-life, practical pro-choice, and logical pro-choice. And I've always done a survey over the years of students, and I would do the same with you if we get you in class, and maybe we can do this through Google Classroom somehow. Looking at the four different positions and seeing, I don't know, which one fits you the most? Which one do you seem to feel more comfortable with? And you're like, well, can we have a definition? What are you talking about? Well, we got the pro-life and we got the pro-choice. Pro-life generally is against abortion. Pro-choice is in favor of the right to have an abortion, okay? Well, so are there other distinctions? Yes. So let's start with this one. Logical pro-life, and you want to put this in your notes and so forth too. Logical pro-life, and you can write this down. This is the Roe versus Wade position. The logical position is what the court has said. Logically, what matters is the female. The female has the complete, full decision-making process at all stages of the pregnancy, even in the very early stages, all the way up until right before a delivery would potentially occur. And so she can have that abortion at any point in time along the way. Now, obviously, a late-term abortion is going to be much more complicated surgically, but she would have that right. It is her right, completely logically hers. Got it? And that is the law of the country, Roe versus Wade. Among pro-choice people, do all of them feel that way? No, a lot of them are fitting into, how do we do this one? There it is, the practical pro-choice. What I describe as the practical pro-choices is people who are in favor of the right to have an abortion, right? So they're in favor of the right to have an abortion, but for practical circumstances, they really don't feel comfortable with, guess what? Late-term abortions, okay? Practical pro-choicers would say, all right, look, you're female, you got pregnant, you don't want to carry the pregnancy to term. have the abortion early on. Don't let the pregnancy go on and on past the point of viability, past the point where now you've got fingers and toes and all kinds of various different things going on and so forth inside. You need to, if you're going to have that abortion, you have that right, but only up to a certain point. And interestingly enough, this is where, like, for example, a lot of European countries are on their abortion laws. Their abortion laws are enacted predominantly from like popular government, the result of elections and so forth. Their courts not quite as powerful as our court, certainly not on this issue. And they come in, in many countries, you have to have if you're going to have an abortion, you have to have it like in the first term or, first several months or whatnot. Okay. In America, you have throughout the pregnancy, but practical pro-lifers would say you have the right to an abortion up to a certain point. Okay. Practical pro-choice. All right. So practical, oh, I messed up all those things. Sorry. I've done it wrong. Started at the bottom. Logical pro-choice. That's what I was talking about. That's Roe versus Wade. Practical pro-choice is what I was just talking about. Right to have an abortion in that first part of your pregnancy. All right. Now, practical pro-life. Started at the bottom. Now we're going up the top. Practical pro-lifers would say, we believe we're against abortion. All right. We're against abortion. We want abortion outlawed. Except we do feel that if a female has a pregnancy resulting from forcible rape, that we don't want to say to that female that she has to carry the pregnancy to term. Okay. And also the practical pro-lifers would say if the female's life is endangered, then at any point in time on the pregnancy that she would have the right to have an abortion. Sometimes you hear it as practical pro-lifers would say that if the female has been raped or incest, okay, well, if it's like a rape incest sort of situation and so forth, then, I mean, that's kind of one and the same thing, arguably, all right? So what are logical pro-lifers? The one right up at the top there. Where do they come in? They're basically saying, okay, the logic is that life begins at the moment of conception inside the womb very, very, very early on, and that life has a right to be protected, albeit inside of another person, a female, but that life cannot be terminated. Okay, so there we go. You have to logically protect that life. So does that mean if the pregnancy resulted from a rape, that female will not have the right to have the abortion? Correct. That's what the logical pro-lifers would say. They say it's not the fault of the unborn. It's not their fault. They shouldn't have to suffer and termination as a result of that. Logical pro-lifers would, for the most part, as I understand, would still give females the right to have an abortion if their lives were endangered. Okay, so that kind of applies on all things. So where are you? Where do you come down on that? We'll see. Right now, Supreme Court has said, logical pro-choice, that's Roe versus Wade. Will it remain that way? We'll see. Keep an eye on the issue. Okay. So, oh my gosh, we did this case before. Another right of privacy case. We talked about this when we were talking about the right to have a marriage and whether or not somebody could get married to somebody regardless of all kinds of various different limitations. Well, the right to privacy has, by the Supreme Court, been expanded into the area of consensual sexual contact among adults, right? In fact, the Bowers versus Hardwick case, 1986, the Supreme Court said, yeah, if a state wants to prevent, people from having intimate sexual relations and so forth who are not married, yeah, the state can do that. That was in 1986. Did the Supreme Court follow the precedent of that case? No. Lawrence versus Texas, 2003, they reversed Bowers versus Hardwick. Make sure you understand that. The Texas case, Lawrence versus Texas, remember that was the two men who were sharing an apartment together, and it was an apartment, and according to the landlord, let the police in, and the two men were in violation of Texas law, and they challenged that law and said that was a violation of privacy. Well, what is privacy? Privacy is what privacy says, and the Supreme Court said that includes consensual sexual contact among adults. So states can't say, we just don't like that taking place in our state, therefore we're going to outlaw it. No, the Supreme Court says that's up to the individuals. There you go. That's it. Oh my gosh. Okay. You got all of the various different notes from this very, very important and thorough, long unit that we've done on civil rights and the courts. And it's been a pleasure. I wish you guys could have been here so we could have had a lot of interaction. I'm going to see if I can figure out a way to get some kind of a survey, because I've done that in previous years on the practical pro-life choices, and it's spread out all over. Last year, it spread out all over. So anyway, take care, stay safe, stay healthy, and hopefully we'll see you soon. All right, bye.